or videos, I'm making things that are going to be intended for showing to relatively small audiences, typically audiences that will go to an event in person and will be shown at a museum or a gallery, and maybe even a copy of the work purchased by a museum or gallery. But really, even if copyright technically could become a problem for a work of that kind, per copyright infringement, for example, the context in which the works are created and shown tends to minimize or eliminate the risk of any practical problems. By contrast,
let me ask you. Okay, so wait a second. So, are you saying? So that's super interesting to me. That really, it's making me think about it really differently. So, is that why? Okay, so if I show a film, I make a film and it's at a museum, and people are taking maybe photographs or something like that, but it's not mass distributed. Or I'm at a quilt show, and even if the 50,000 people come and see my quilt, but at the same time it's not, and maybe people take photographs of it, but it's not out there in a again, mass commercially produced way. That's a distinct category that you're saying that because of sort of the nature of the audience. If you took that same thing and just put it up online for everybody to see it, would that, and still didn't charge anything, would that make any difference to it? Is it the non-commerciality of it? Or I know you're going to get to your second example, but I'm curious how you're defining that first example.
Right. I mean, I think it's a kind of constellation of structural features, right? So in sort of the paradigmatic case of a painter or a sculptor working on a unique object, it's very common, especially today, but it has been for quite some time, for people to incorporate materials from all manner of different sources into their work. A collage or appropriation aesthetic takes many different forms, all of which are, technically, potentially copyright infringing. But I think only rarely does that kind of appropriation become a practical problem for artists. So we see certain examples of, high profile examples of, very commercially successful artists being sued for copyright infringement. But I think that's misleading, because the volume of that kind of borrowing and appropriation that goes on vastly exceeds the amount of litigation that takes place, right? So it suggests to me that the litigation is an anomaly, and it's an anomaly that kind of crops up for two kind of interrelated reasons. One is, if copyright owners see the appropriation taking place, they become aware of it, in some cases they want basically to partake in some or all of the financial success of the person doing the appropriating, right? So if there's a pot of money available, then people will go after it, unsurprisingly. And in other cases, they object to the way the use is being made.
Right.
And so, the application of copyright to an infringement action is really intended more as a way of managing the speech of a third party, which arguably isn't the kind of thing we want people to be using copyright for, although they do all the time, right? Where I think copyright becomes much more relevant to artists is when you start to move out of the sort of fine art scarcity world, broadly defined, into an increasingly commercial area, right? So when I made art films for showing in museums and galleries, right, they weren't being shown or distributed in a context that would make them relevant to anyone whose copyrighted works were being borrowed or used in any way. But by contrast, when I produced the documentary film Our Nixon, which ended up being picked up by a national distributor and shown on CNN and so on. Well, in that context, right, it was being shown commercially by a commercial broadcaster and distributed by a commercial distributor. And so copyright questions became much more relevant and salient because the work was being sold in a marketplace that copyright was designed more directly to regulate in the first place, right? So we needed to think more about ensuring that, we were going to insulate the work from any potential copyright infringement actions and also get errors and omissions insurance to sort of mitigate any potential risk of an infringement action.
Super interesting. So it just changes the game. Then you need permissions and see whether it's in public domain or fair use, and like you're really fully into the sort of legal analysis of. But when you were making the film, well, let me ask you: when you were making the film, did you consider and think about the copyright issues that might arise from what materials you were choosing?
Yeah, absolutely. Right. So we used, the film, I think, is interesting from a copyright standpoint because it's entirely a collage film. Right. So virtually every element of the movie was made by someone else. And so, we could only have an authorship interest ourselves in the construction of the film, not the actual content of any particular images or sounds, right? So some of the elements that we used were public domain works. So, motion pictures made by government employees. So those we could use with impunity because, of course, there was no copyright protecting them at all. Others were kind of news media material, which, is copyrighted material, but because of the context in which we were using it and the way in which we were using it, to illustrate historical events, we made fair use claims with respect to basically all of that material. There were some news clips that we couldn't get a hold of from a kind of open source, and so we had to form contractual relationships with the copyright owners. So in those cases, we had to license, not because there was a copyright issue around licensing, but because, we made a contractual agreement to license the material if we were going to use it. And so, it would have been a breach of contract not to license, even though the uses we were making were probably fair uses. And then in other contexts, specifically, like, for example, the music we used over the opening credits, right? We felt like that was a stretch for the fair use doctrine because, we were picking this song not just to comment on the movie, but also kind of on its own merits. And so, initially we wanted to use the Carpenter's Superstar, but when we finally got in touch with some of Richard Carpenter's people, as they were, we were informed that Mr. Carpenter doesn't usually allow people to license, get sync licenses for the Carpenter's music. And when he does, the starting price for a license would be in the low six figures, which was, basically the budget of the entire movie. So,
right.
so that was, copyright. Yeah, copyright made that no longer an option.
Right.
For
so funny. I think that the pricing is really interesting because it's allowing the copyright holder to control who uses it and who doesn't. Like, that's an interesting way to control it in terms of permissions. Mm-hmm. We were trying to use Girls Just Want to Have Fun as our opening song, and it was impossible because sort of what they wanted, it was like, I don't know, ridiculous amount per episode. They're like, well, how many episodes you're going to do? I'm like, I don't know, many as I can, right? So it became really interesting that we had to use, then we went to podcast music and that there was a whole licensing scheme there and it was much easier and super cheap and it was all good. But it's interesting to see that I think that element, like, it does change the creativity and that sort of, you change the song, it may be for the best. Like, you go, oh, I found a better song. But it's interesting to see where those moments do happen where you can't clear. It's too expensive. Yeah.
Yeah, no, that's absolutely right. It ended up being all right because we used a Tracy Ullman covering. forget. But the song They Don't Know. And it was a much more, Christy McCole's song, They Don't Know. So, and Tracy Ullman was super nice about it and gave us a real bargain on the song. So thanks, Tracy, you're awesome. Anyway, but, it did affect the creative process, absolutely. And I think having to be conscious and cognizant of potential copyright related issues absolutely affects the creative process, and for people who aren't law professors like me, right, it can scare them off from doing things that they would otherwise do. So I frequently find myself, kind of talking people through that process when they start thinking about making commercial films, to try to help them get a handle on sort of what kinds of things they should worry about. And by contrast, what kinds of things they shouldn't worry about quite so much. But yeah, and I think this goes to it like a deeper problem in some ways with copyright law, because there's so many values. You
think copyright has some problems? I'm just kidding.
Yeah.
I'm just kidding. Like, that's all we talk about. As law professors, it's like all the problems there are with copyright. So tell me what you think is the deeper problem with copyright.
Yeah. Well, I think there's so many competing values bound up in copyright, both theoretically and in practice. So I think it's tempting for us to think of copyright owners schematically as kind of rational economic actors, sort of working in a highly negotiated field. But the reality is that, sometimes that's true when you've got, kind of large corporate entities that own a whole bunch of copyrighted material and have an interest in, making it available as broadly as possible at market prices, right? When that happens, fantastic, right? You've got your perfect kind of quasi-Coasian marketplace. The problem is that, in my experience, artists are rarely rational economic actors or frankly rational in any way. And that definitely can enter into the equation, right? I mean, Richard Carpenter is clearly not acting as a profit maximizing copyright owner when he sets, impossibly high fees to license the Carpenter's music. I mean, basically what he's doing is putting barriers in the way of people using it the same way that,
and he can do that because he's a copyright holder. So that's the way the system's built.
The system is absolutely, for better or worse, the system is absolutely built that way. Part of me questions whether it should be, right? Or, if we, to the extent we do think the system should be that way, what does that tell us about the normative values embedded in what we're doing when we do copyright? And I would say by extension, right, to the extent we think that those kinds of normative First Amendment laden problems are an acceptable or even kind of an aspect of copyright management that we encourage, is that inconsistent with the stories we tell ourselves about kind of the underlying economic rationale for copyright, right? In other words, can we coherently keep both of those justifications in mind at the same time? And then beyond those kind of normative, really First Amendment laden problems, I think, the reality is that most copyright licensing markets are heavily inflected by transaction and specifically information costs, right? Which make them much less efficient than people often want to think they are. And you kind of managing.
So explain a little bit. Okay, so first explain a little bit about what you mean by that. So give me an example of what you're talking about.
Right. Well, if you want to, for example, license music for a movie, you have to figure out who the owners of the rights in all that music are, and then you have to negotiate individually with each one of those owners.
Right.
If you're using 20 or 30 different songs in a movie, that can be quite burdensome indeed. Plus, at what stage in the production do you do that, right? How do you negotiate individually with all these different copyright owners, and then the same thing